Good afternoon, everybody. Welcome to our 2021 Coase Lecture. It's a real pleasure to welcome you to this event, this great tradition that we have. From its very beginnings, the law school, as a professional school within a research university, has been committed to interdisciplinary scholarship. Our faculty have sought to draw on knowledge and methods from other disciplines in order to do path-breaking scholarship that creates new paradigms for understanding law, legal institutions, and our world at large. Scholarship that often challenges, even upends conventional wisdom. One of the most powerful examples of these values is economic analysis of law, or law and economics. Law and economics has influenced our understanding of so many fields of law, and within some fields, it is the primary methodology for understanding law. In little more than a generation, it's become a standard feature of legal education throughout the United States. And it was born right here at the University of Chicago. Ronald Coase, who was the Clifton Musser Professor of Law and Economics, was one of the most important contributors to this field. He powerfully deployed the ideas of economics to help us understand law and legal institutions. Now, I'm sure many of you are already familiar with the so-called Coase theorem, the idea that was contained in his highly cited and very influential article, The Problem of Social Cost. But Professor Coase also made important contributions in understanding the allocation of spectrum by the Federal Communications Commission, durable goods monopolies, the private provision of public goods, and the theory of the firm. Indeed, Professor Coase was the founder of what we now call transactions cost economics. In 1991, he received the Nobel Prize in Economics, and he was the first professor in a law school to receive a Nobel Prize in Economics. If I'm not mistaken, he remains the only professor to have done this. And in 1992, this lecture series was founded to honor him and to continue the type of path-breaking interdisciplinary scholarship that he began. The specific purpose of this lecture is to share an idea from law and economics with our students, especially our first-year students. There'll be a time for questions, so I encourage all of you to think about your questions as we hear from our speaker. And I'm delighted and honored to introduce today's speaker, Professor Daniel Hemel. Professor Hemel is Professor of Law and, very fittingly for today, the Ronald Coase Research Scholar. Professor Hemel is a person of enormous intellectual energy and ambition. Students who have taken a class with him, whether it's torts, basic tax, administrative law, or something else, you know this. You've seen his energy and his ambition. And if you've not had a class with him, Professor Hemel's intellectual ambition and energy are evident in his career trajectory. He graduated summa cum laude from Harvard College. He received an MPhil with distinction from Oxford, where he was a Marshall Scholar. And then he earned his JD from Yale, where he was editor-in-chief of the Yale Law Journal. He then proceeded to clerk for no fewer than 3 federal judges: Judge Michael Boudin of the U.S. Court of Appeals for the First Circuit, Judge Srinivasan of the U.S. Court of Appeals for the D.C. Circuit, and then for Associate Justice Elena Kagan of the U.S. Supreme Court. Along the way, he also served as visiting counsel for the Joint Committee on Taxation. His energy and ambition became even more evident when he joined our faculty. In fact, I remember when we interviewed Professor Hemel for a position on our faculty, and we had to schedule that interview around his commitment to run a marathon. Now, most people try to conserve their energy before a grueling set of interviews with our faculty. Professor Hemel instead ran the ultimate long-distance road race the day before he interviewed with us. And since joining our faculty, Professor Hemel's energy has reached new levels. He has authored dozens of academic articles that span an incredible range of topics, from tort law, most recently COVID liability for businesses, to intellectual property, trademark, patent, innovation policy generally, to the structure of administrative agencies, to free speech, and most of all in tax, from basic tax to the taxation of wealth, the taxation of marriage, charitable deductions, and more. Were all this not enough, Professor Hemel is a prolific author beyond the academy. He has produced many op-eds and columns on a vast array of contemporary topics, and he has issued more tweets than I can count. So it's very fitting that for today's Coase lecturer, we have an energetic mind speaking on the topic, law and the new dynamic public finance. Please welcome our 2021 Coase lecturer, Professor Daniel Hemel. Professor Hemel, would you be so kind as to unmute?
Now unmuted. Success. I think we're good. Great. So this year marks the 50th birthday of modern optimal tax theory. The field's dawn can be dated to an article published by James Mirrlees in the April 1971 issue of the Review of Economic Studies. Mirrlees sought to derive the income tax schedule that would maximize a utilitarian social welfare function, given certain assumptions regarding individual preferences and economic parameters. His effort was intellectually a great leap forward. It continues to shape the way we think about inequality and redistribution today. The technical constraints of the era, however, required Mirrlees to make a number of simplifying assumptions. Mirrlees's model envisioned a one-shot game. The natural lottery endows individuals with innate skills. The government sets the income tax schedule. Individuals choose their labor supply, and then the game is over. There is no time dimension. Skills do not evolve. Individuals do not save. No one ages, no one dies, no one bequeaths or inherits wealth. Government policy remains constant. To quote the statistician George Box, all models are useful. All models are wrong, but some are useful. And indeed, the static Mirrleesian model has proven to be quite useful. It has produced crisp implications for taxation of top labor incomes with particular policy relevance in an age of increasing inequality. But it offers little guidance with respect to other important questions in tax policy. It doesn't tell us whether and how characteristics such as age and earning history ought to enter into the tax function. It doesn't tell us how savings and inheritances should be treated. It doesn't tell us what tax instruments should be available to the government and what instruments should be constitutionally prescribed. The new dynamic public finance literature starts from the static Mirrleesian model and sets it into motion. Individuals age and their incomes rise and fall. They can save, and when they die, they can bequeath their assets to their children. The government, meanwhile, sets policies not just once, but repeatedly. In some applications, the government can commit to future tax schedules. In other iterations, the government is like George H.W. Bush. It may say, read my lips, no new taxes, but its promises aren't necessarily credible. The static Mirrleesian model is reasonably familiar to tax lawyers, or at least to tax law academics, and to some of our students who take intro income tax. More than 130 law review articles cite Mirrlees's 1971 paper directly. Hundreds more reference a 1987 article by law professors Joe Bankman and Tom Griffith that explained the static Mirrleesian model to fellow lawyers in non-technical terms. By contrast, the new dynamic public finance literature is largely unknown in the legal academy. A handful of legal scholars, including our own Lee Fennell and David Weisbach, have taken note of key findings. Professor Fennell in her work on age-dependent taxation, Professor Weisbach in his writing on disability law. But outside of this Zoom room, the number of legal academics who have engaged with the new dynamic public finance literature at any length is countable on two hands with fingers to spare. The central thesis of my talk today is that this ought to change. The insights of the new dynamic public finance are relevant not only to tax law, but also to constitutional law, contract law, consumer credit law, and labor and employment law, among other fields. Meanwhile, insights from legal scholarship have important implications for economists working in the dynamic Mirrleesian tradition. The overlap between law and the new dynamic public finance is fertile, but largely unharvested terrain. I will focus today on four topics where the potential for cross-pollination between law and dynamic public finance is particularly strong. Labor income taxation, especially age-dependent taxation, capital taxation, inheritance taxation, and a set of problems that fall under the rubric of dynamic political economy. The coverage is far from comprehensive. For example, the optimal tax treatment of human capital in dynamic settings is an active area of research that today's talk totally leaves out. My objective is to illustrate the promise of law and the new dynamic public finance as a research agenda, not to exhaust all insights. I'm also going to do something that any economist in the Zoom room will find totally blasphemous. I will give today's talk without presenting a single equation. While the math is, of course, important to the enterprise, my working hypothesis, which might be refuted, is that most of the key concepts are and ought to be explicable to lawyers with limited economics training. The natural launch pad for this discussion is Mirrlees's 1971 article. Mirrlees begins with a static model with a population of individuals who have identical preferences, but different endowments of natural skill. Skill here refers to income earning ability and should have absolutely no moral connotation. An individual's income is determined by her labor effort and her skill level. The government can observe individuals' incomes, but it can't directly observe their effort or skills. Since this is a one-period model, there is no saving. All income is either taxed away or consumed. Mirrlees' social welfare function was utilitarian, and the social marginal utility of consumption was declining. If labor supply were inelastic, which means if people work the same amount regardless of their after-tax wage, then the optimal income tax schedule would entail a 100% tax rate with a uniform lump sum subsidy or demogram. In other words, if we could divide up the economic pie any which way without reducing the pie size, we would opt for perfect equality. Redistribution, of course, is not costless. Higher income tax rates typically induce individuals to choose less labor and more leisure. The government in Mirrlees' model must balance the redistributive benefits of taxation against the labor discouraging costs. This is the classic equity efficiency trade-off in tax law. Mirrlees sought to derive tax schedules that would maximize social welfare. One curious result that emerged from his model was the idea that the marginal rate on the very last dollar of income for the very highest skilled individual should be zero. In Mirrlees' view, that result, though it has become quite well known, has little practical value. A more useful question to ask in Mirrlees' view was what top bracket rate would maximize revenue. At very high incomes, the social marginal utility of consumption is very low. We don't care all that much about an extra dollar of Jeff Bezos' consumption. And so the utilitarian social planner should raise the top marginal rate until raising it any more won't generate additional revenue. The most important work on this topic comes from Mirrlees' most frequent collaborator, MIT economist Peter Diamond, and his former doctoral student, Berkeley economist Emmanuel Saez. In a 2011 paper, Diamond and Saez estimate that the revenue maximizing top rate in the United States would be approximately 73%. For comparison, the all-in top labor income tax rate in California, factoring in federal income taxes, federal Medicare taxes, and state income taxes, is now approximately 53%. So Diamond and Saez's calculations suggest that there are substantial welfare gains to be had from high-end rate hikes. At the bottom of the distribution, Mirrlees' model yields the clear conclusion that the government should provide a lump sum subsidy akin to a universal basic income. The implications of his model for low-end marginal tax rates are somewhat more ambiguous, but suffice it to say that the model generates concrete recommendations regarding some aspects of tax policy and vibrant debates about others. But while there is much that the static Mirrlees model can tell us, there's also much that it cannot. The static Mirrleesian model doesn't tell us much about the taxation of savings and inheritances. It doesn't tell us how taxes should evolve over the life cycle or over political history. These are important questions for lawyers, and we would like our answers to be economically informed, but that will require us to look beyond the static Mirrleesian model. The dynamic Mirrleesian approach differs from its predecessor, both in its assumptions and its methods. As in the static model, nature deals each agent an initial endowment of skills. But then, unlike in the static model, nature deals a series of stochastic or random skill shocks, which can be negative or positive. Think of these skill shocks as anything from a car crash that renders the agent disabled to a lucky break at work that results in a promotion, or a global pandemic that makes some skills less valuable and others more so. Methodologically, the dynamic Mirrleesian approach typically begins with a set of incentive-compatible allocations limited only by what the government can observe. These allocations are characterized by wedges or distortions to labor and savings choices. The analyst solves for labor and savings wedges that satisfy Pareto efficiency or alternatively maximize social welfare. Taxes allow the social planner to implement the optimal wedges, though that is only one means of implementation. For example, we could think of disability insurance as having a wedge schedule of its own. We can also think of the tax and transfer system as an insurance policy, purchased by individuals behind the veil of ignorance, before they know the results of the natural lottery and then the stochastic shocks that will follow. Greater progressivity generally corresponds to more insurance coverage. This shift in focus has rhetorical and analytical payoffs. Rhetorically, it changes the theme of optimal tax debates from class conflict to risk management. The case for progressive income taxation comes to resemble the case for universal health insurance, not simply a matter of the government shifting resources from one group to another, but a matter of the government providing something of value to everyone. The analytical payoffs are several. I'll start with the issue of labor income taxation and then move on to questions of capital taxation, highlighting lessons for the law along the way. The figure on your screen illustrates two stylized facts about income over the life cycle. First, income generally rises with age. Second, and even more starkly, the dollar gap between high income and low income individuals widens considerably with age. We become a much more unequal society as we age. To understand the implications for taxation, think again about an individual behind the veil of ignorance who is purchasing a series of insurance policies. Each policy pays out at a particular age. The individual would want to buy more insurance for older ages because income risk is higher. This would seem to suggest that tax rates should increase with age. But the increasing insurance rationale is only one element of the optimal age-dependent tax schedule. A second element, emphasized by a paper by Ndaye in 2017, is the changing elasticity of labor supply over the life cycle. Around the typical retirement age, the responsiveness of labor effort to taxation rises considerably, and taxes become more distortionary. This phenomenon offers a strong rationale for lower labor income taxes at older ages. When we put these together, we get something like a hump-shaped age tax schedule, with taxes rising from youth until around 64, and then falling after that. Ndaye estimates that such a system would yield welfare gains equivalent to a 1.75% increase in aggregate consumption. This is quite substantial, at least by the standards of tax interventions. Two other aspects of age-dependent taxation merit mention. One is the intertemporal elasticity of labor income. When marginal rates change over the life cycle, individuals face a distortionary incentive to move earnings from high-rate periods to low-rate periods. The intertemporal elasticity includes both a real response and an income-shifting response. The real response occurs when an individual, say, works extra hours in December of a low tax year and then sits at home watching Netflix in January of a high tax year. The income shifting response, which is potentially much larger, occurs when employers and workers structure pay arrangements so that workers realize income in different years than when they perform the compensated labor. For example, a signing bonus brings income from the future to the present, while a pension pushes income from the present into the future. Another element is the functioning of credit markets. With perfect credit markets, individuals can smooth consumption over the life cycle by borrowing in their 20s and their early 30s, and then repaying that debt in their highest income earning years. When credit markets are imperfect, borrowing may be constrained, in which case age-dependent tax systems can smooth consumption across the life cycle by transferring resources from the middle-aged to the young. Age-dependent taxation is an active topic of dynamic public finance research. It is also a topic where law and economics can inform each other. Economists who study age-dependent taxation typically take central parameters as given. The skill shock process simply is what it is. Relevant elasticities and credit market efficiency are also exogenous. They're just givens in the model. This may make sense if we're trying to break a complex problem into chewable chunks, but we should keep in mind that these parameters are to a substantial degree determined by law. Professor Weisbach and I make a similar paper about the overall elasticity of taxable income in a working paper. Our working paper uses a Ramseyan representative agent setup without heterogeneity or a time dimension. The dynamic Mirrleesian model multiplies the range of tax and law interactions. To make the point more concrete, consider potential responses to age-dependent tax schedules. For tax rates that decline with age, the incentive is to push compensation into the future. Tax lawyers have developed a technique called the rabbi trust, the initial clients were in fact rabbis, that works well as a deferred compensation structure. And even if Congress banned rabbi trusts, it would be pretty easy to write an employment contract under which the worker receives less than her marginal product of labor in early years and more in her later years. Arguably, this is what university faculty tenure accomplishes. At least under current law, courts will enforce those contracts. For tax rates that rise with age, the incentive is flipped. Employees want contracts that front-load compensation. But it's actually very hard to stop an employee in the later years of a front-loaded contract from quitting. Courts generally won't grant specific performance as a remedy in labor contracts, meaning they won't issue injunctions ordering employees to work for a particular firm. Employers might try to lock employees into long-term contracts, but by including non-compete provisions. But this won't work in California, where non-competes are unenforceable. And even if states change their laws to allow specific performance or to enforce non-competes, we simply haven't developed a legal technology that prevents an employee in the later years of an employment contract from slacking on the job. Thus, the income shifting component of the intertemporal labor elasticity is likely to depend on whether tax rates rise or fall with age. If tax rates rise with age, income shifting is less of a problem. There's less of an incentive to push income later in life, and it's hard to push income earlier in life. If tax rates fall with age, then the problem is acute. The Ndiaye 2017 paper finds that the welfare gains from age-dependent labor taxes are substantially higher on the left side of the hump than on the right. In other words, age-dependent taxes would be worthwhile even if we could only make tax rates rise and never make them fall. Here, law sheds light on which prescriptions from dynamic public finance are likely to be implementable. And here the takeaway is on balance encouraging. Not only is law an important input into age-dependent tax schedules, but the age dependency of the tax schedule is an important input into law. Some of the benefits of an age-dependent tax schedule are benefits that the private sector can potentially provide. Credit markets can facilitate consumption smoothing. Labor unions ensure against later in life skill shocks. These institutions are heavily regulated. The optimal shape of regulation will depend in part on the extent to which the public sector already supplies the benefit in question. So, for example, a major focus of consumer financial regulation is ensuring that individuals don't take on too much debt. The concern being that unscrupulous lenders may induce financially unsophisticated individuals to overborrow. But debt is also a way for younger workers to smooth consumption across the life cycle, which is something the government should want to facilitate. So the optimal stringency of consumer financial protections may depend on the extent to which the tax schedule already facilitates consumption smoothing. Or somewhat further afield, marriage is a reasonably effective mechanism for ensuring against later in life skill shocks. It is also an institution created by law that can be encouraged or discouraged by law. How much we want to encourage marriage may depend, at least in part, on how much skill shock insurance the tax system already provides. There is much more to be said about age-dependent taxation. Professor Fennell's 2005 article with Kirk Stark delves much more deeply into the subject. And if there is ever a law and dynamic public finance canon, as I hope there will be, that paper will be the genesis or the exodus. With respect to age-dependent taxation, the new dynamic public finance literature is largely reformist. With respect to capital taxation, by contrast, dynamic public finance helps to justify features already found in most advanced economy tax systems. To understand the dynamic public finance literature's contribution to capital taxation, it will be helpful to survey the state of play before dynamic public finance came onto the scene. The benchmark model of capital taxation in the public finance literature is from the late 1970s onward, comes from a 1976 article by Tony Atkinson and Joseph Stiglitz. For a fuller explanation of the Atkinson-Stiglitz model that is accessible to readers with no economics training, I highly recommend Joe Bankman and Professor David Weisbach's crystal clear Stanford Law Review article from 2006. Atkinson and Stiglitz extend the static Mirrleesian model over 2 periods. Everyone works in period 1 and retires in period 2. Individuals save some of their period 1 income to finance period 2 consumption. Now let's imagine that we introduce a tax on savings or capital. This distorts period 1 labor choices because now period 1 labor can buy less lifetime consumption, assuming that individuals plan to save at least a little. This also distorts decisions about how much to consume in period 1 and how much to save for period 2. So we have a double distortion. Now let's imagine that we eliminate the capital tax and increase the period 1 labor income tax so that the government raises the same present value of revenue from each individual as before. The government is by construction no worse off, and individuals are better off because they're paying the same in taxes, but their savings choices aren't distorted anymore. This in turn allows the government to accomplish more redistribution. High-skilled individuals are now happier with their high incomes because their savings choices are no longer distorted. That in turn means that we can tax them even more without inducing them to choose lower labor effort. Atkinson and Stiglitz's zero tax result dovetailed with a pair of papers from the mid-1980s by Christoph Chamley and Kenneth Judd, who used very different methods, but also found that the optimal capital tax rate is 0 in the long run. Within the economics profession, Atkinson, Stiglitz, and Chamley, Judd cast a long shadow over capital taxation into the early 2000s. Roughly a generation of college economics majors learned that non-taxation of capital is ideal. The zero capital tax result also left a cloud over the study of capital taxation in the legal academy. With Atkinson, Stiglitz in the background, figuring out how to fix capital taxation seemed a little bit like figuring out how to fix a fax machine. Right? No one is sure why we still have the object, so why bother? For many of our students, the result was rather dispiriting. Most upper-level tax courses in law schools focus on capital taxation of some sort, including corporate tax, estate and gift tax, and international tax, which is largely about the cross-border taxation of capital. These are devilishly difficult subjects, and it's demoralizing for students to devote hours and hours to the details while their professors tell them that, according to the benchmark models in economics, these subjects ought to be scrapped. Enter the dynamic Mirrleesians, including Mirrlees himself, whose work on pensions actually laid the foundation for the new dynamic public finance. The seed can be found in a 1978 paper by Diamond and Mirrlees on pension policy, though it wasn't until a 2003 article by Golosov, Kucher-Lakota, and Savinsky that the application to capital taxation was broadly understood. Starting from Atkinson Stiglitz as a benchmark, the dynamic Mirrleesian approach makes two key analytical moves. The first is to add the possibility of multiple periods of work. The second is to introduce uncertainty regarding period 2 skills. To keep things as simple as possible, let's imagine that everyone works in period 1 and that some individuals experience a random shock that renders them incapable of work in period 2. The government insures against disability by transferring resources from second period workers to second period non-workers. The second period insurance benefit introduces moral hazard. Now, some individuals who don't experience the negative shock choose to mimic in order to claim benefits. This drains resources from individuals who are truly disabled. The challenge for government is to devise a mechanism that discourages the work capable from mimicking. Diamond and Mirrlees suggest that a tax on savings can serve this role. The idea is that first period workers who plan to mimic in the second period will want a smooth consumption across the 2 periods. They'll want to save more while they're working so that they can maintain their level of consumption when they're not. A tax on capital increases the cost of this save and mimic strategy and thus mitigates the moral hazard problem. As Golosov et al. 2003 show, this insight applies outside the disability insurance context to income redistribution and social insurance more generally. The incentive for high-skilled individuals to choose low incomes is stronger if high-skilled individuals have accumulated significant savings from earlier periods. Capital taxation can ease the incentive compatibility constraint, allowing the government to redistribute more to individuals who are truly low-skilled. For legal scholars, the implications of Diamond Mirrlees 1978, Golosov et al. 2003, and subsequent extensions are enormous. First, the insights of the dynamic Mirrleesian model reinvigorate the study of capital taxation. Tax law scholars no longer need to be agnostic or apologetic about the enterprise. Capital taxation can command true belief. At least for those of us who teach and study the subject, this is no small thing. To be sure, the capital tax rates that emerge from these models aren't enormous, but they are potentially in the range of those that currently apply in the United States. Second, in addition to providing a justification for capital taxation, dynamic public finance offers guidance as to the regime's shape. The dynamic public finance literature suggests, perhaps surprisingly, that higher capital tax rates should apply to individuals with lower labor incomes. Recall that capital taxation is being used as a tool to deter high-skilled individuals from choosing low incomes in later periods. A capital tax that is declining over labor income responds to the particular moral hazard from accumulated savings. This result might seem normatively unattractive on first glance, but note that the regressivity of the capital tax comes in service of a more redistributive labor tax. By making the save and mimic strategy less attractive, a capital tax targeted at individuals with low labor incomes reduces the efficiency cost of income redistribution, thus allowing us to do more of it. The big beneficiaries are individuals who truly have experienced negative skill shocks and haven't accumulated substantial savings in anticipation. Capital taxes with marginal rates that are regressive over the labor income distribution actually have real-world precedents, and this is arguably a case of theory catching up to practice. For example, in order to claim the earned income tax credit in the United States, you can't have investment income above $3,650. This limit acts as a capital tax with a cliff-like structure that applies only to individuals with low labor incomes. A similar example is the Medicaid asset test for the aged, blind, and disabled. A paper by Golozov and Savinsky in 2006 suggests that asset tests for disability insurance can generate substantial welfare gains. This last observation about asset tests for disability insurance leads to a third analytical payoff: the potential substitutability of capital taxation and other screening mechanisms. Papers in the dynamic Mirrleesian tradition generally assume that the government can't observe disability or need except by virtue of income or assets. But of course, the government does have other ways to detect disability, albeit imperfectly. For example, the Social Security Administration evaluates disability benefit applications by reviewing medical records and taking testimony. Disability benefit denials are among the most frequently litigated issues in the federal court system, with nearly 20,000 cases in district court each year. If you go on to clerk for a district judge, you will almost inevitably work on one and probably several of these cases. Quite a few of these cases have reached the Supreme Court, and no doubt the most famous is Matthews versus Eldridge, which is regularly taught in courses on constitutional law, administrative law, and civil procedure. By a 6-2 vote, the justices held that the agency could cut off benefits to Mr. Eldridge when the agency suspected, on the basis of written submissions, that he wasn't truly disabled. A key part of the court's reasoning was that in order to preserve program resources, the agency needed a relatively low-cost way to cut off benefits to suspected mimickers. Matthews versus Eldridge foregrounds the trade-off between approaches toward the provision of public benefits and social insurance that emphasize qualitative factors and quantitative factors. The qualitative approach that we see in Eldridge involves a searching inquiry into the lives and health records of claimants. The quantitative approach determines eligibility based on numerical indicators of need, such as age and income. For example, expanded Medicaid coverage under the Affordable Care Act is available to adults ages 19 through 64 with household incomes below 133% of the federal poverty line. That's it. There's no search into your health records or to your work capability. Qualitative approaches tend to delegate great power to mid-level government officials who are tasked with making inevitably subjective judgments. And as Jerry Mashai has observed, such judgments also tend to carry a moral element. For the state to say to Mr. Eldridge that he isn't really disabled has more dramatic dignitary consequences than for the state to say, matter-of-factly, that a person isn't eligible for a benefit because her assets are too high. Qualitative approaches also raise difficult questions of privacy and procedural due process. How much is the government entitled to know about the details of a mental illness that renders an individual incapable of work? And as was the issue in Eldridge, what sorts of opportunities must the government allow for claimants to present individualized evidence to a decision maker before benefits are denied or discontinued? The primary advantage of the qualitative approach is that it more effectively weeds out mimickers, thus allowing the government to concentrate aid on people truly in need. Whether this advantage outweighs the costs in terms of administrative expense, privacy intrusions, dignitary damage, requires a complex calculus involving difficult to commensurate values. But one key input to this analysis is the potential efficacy of the quantitative alternative. How well can a quantitative approach, relying only on factors such as income and assets, screen out claimants whom the qualitative approach seeks to screen out through more hands-on means? The dynamic public finance literature teaches us that a quantitative approach based on income and assets can do substantially better than an approach based on income alone. In the disability context, capital taxation and medical examinations can be substitutes of sorts. To be sure, quantitative and qualitative criteria aren't necessarily either or, and some social insurance and public benefit programs incorporate both. But at the very least, legal scholars and policymakers designing these programs need to understand the screening potential of capital taxation, a subject on which dynamic public finance sheds light. So far, the discussion of capital taxation has focused on savings and labor decisions across a single lifetime. Another focus of inquiry in the dynamic Mirrleesian tradition is the intergenerational transfer of wealth. Here too, the new dynamic public finance has generated insights with clear legal relevance, and law can potentially inform economics as well. To gain some analytical leverage on this subject, let's return to the Atkinson-Stiglitz model. But now imagine that agents in period 1 and 2 are different generations of the same family. Parents work in period 1, and they bequeath a portion of their income to children in period 2. If different generations within the same family have unified utility functions, then the zero capital tax result of Atkinson-Stiglitz applies to bequest taxation. We've just redescribed the Atkinson-Stiglitz model, but called the people in period 2 children. A tax on bequests, like a tax on savings, unnecessarily distorts the parent's bequest choices. It introduces the same double distortion. Now let's add the possibility that children can work in period 2. If leisure is a normal good, bequests will reduce children's labor supply through the income effect. This was incidentally why Andrew Carnegie said he would only leave a small trust for his daughter and eventual grandchildren, and he followed through on that. From here, the dynamic public finance literature makes several key moves. One is to introduce the possibility of accidental bequests. Some individuals show little apparent concern for what will happen to their assets after their death. They might not have any intention to leave a bequest, but they die prematurely without having spent down all their wealth. The singer-songwriter Prince Rogers Nelson, who died in 2016 without a will or any evident estate plan, is a good example. If Prince didn't care about what would happen to his assets after his death, then an estate tax, even at 100% rate, might not have any significant labor discouraging effect on him. If that's the case, why not confiscate his assets at death and then redistribute the wealth broadly? If the government can't distinguish between accidental bequests and intentional ones, then the existence of accidental bequests drives up the optimal bequest tax rate. A paper by Peterman from 2013 introduces the interesting possibility that maybe the government actually can distinguish between the two. In that case, the optimal tax rate on accidental bequests is very high, while the rate on intentional bequests is lower. The idea that the government would be able to distinguish between accidental bequests and intentional bequests might seem far-fetched on first glance, but upon further reflection, it arguably reflects the current US estate tax system. The estate tax is sometimes called a voluntary tax because anyone who plans far enough in advance stands a pretty good shot at avoiding it. But many of the avoidance techniques, like grantor retained annuity trusts, are quite complicated and require sophisticated advanced planning. So if a high net worth individual doesn't care about what will happen to her assets after death, she will, like Prince, probably end up with a large bill. The current loophole-ridden regime might be recast as a successful example of a costly screen that separates accidental bequests from intentional ones. Aside from accidental bequests, another rationale for bequest taxation is altruism heterogeneity. This is an issue addressed in a paper by Farhi and Werning from 2013. One way to access the intuition is to imagine that the children's generation starts behind a veil of ignorance. To make the model as simple as possible, let's assume that children will have the same skill level as their parents. Before children are sorted by the natural lottery into families, there are two key facts about their futures that they don't know. First, they don't know their family's skill levels. And second, they don't know their parents' generosity. They would want to ensure against the outcome of being low skilled through a system of redistribution on the basis of skill. And they would want to ensure against the outcome of having less generous parents through a system of redistribution based on parental altruism. Now, the government can't observe skill levels or altruism levels directly, but it can observe income and it can observe inheritances. Children behind the veil would opt for a system that redistributes from high incomes to low incomes and from people who receive large inheritances to people who receive small inheritances. An inheritance tax will distort parental bequest decisions, just as an income tax will distort labor-leisure choices. But the distortion isn't a reason to discard the tax. Rather, the optimal inheritance tax balances the insurance benefit against the bequest discouraging cost. This analysis has a number of important implications for law. Only a few of which I'll highlight here. A key question in the design of an intergenerational wealth transfer tax is whether the tax should be levied on estates or on inheritances. The difference is that an estate tax is measured by the amount that the decedent leaves to all her heirs combined, while an inheritance tax is measured by the amount that each person receives over the course of her lifetime. The difference becomes significant if the wealth transfer tax either incorporates an exemption amount or applies a progressive rate structure. The altruism heterogeneity argument suggests a rationale for choosing an inheritance tax, which is not what we have in the United States, over an estate tax, which is what we have. An estate tax insures against the risk that one's parents will be less altruistic. An inheritance tax insures against that risk, but also the risk of being born into a family with lots of children who spread their parents' assets thin. So the inheritance tax provides a more complete insurance product. A final theme in the dynamic public finance literature is the possibility that bequests might bring a sort of double benefit: warm glow to the parent and consumption utility to the child. If the parent thinks only about the warm glow of giving but doesn't fully take into account the child's consumption utility, then there's a positive externality to bequests. And if bequests generate positive externalities, then they ought to be subsidized, not taxed. Some papers in the new dynamic public finance literature take this intuition seriously and run with it. They typically find that the optimal bequest tax is both progressive and negative. All bequests ought to be subsidized, but the subsidy should be smaller for larger bequests. There are two reasons, though, to take the subsidy prescription with a grain of salt. The first is in the spirit of this lecture's namesake. A Coasian perspective on the family would emphasize all the ways in which families internalize costs and benefits. The idea that intrafamily transfers yield large and uninternalized benefits overlooks all the opportunities for low transaction cost exchanges between parents and children. A second cause for caution is that a subsidy for bequests would be really hard to administer. One reason why the estate tax base is so porous is it's very easy to transfer, for a parent to transfer wealth to a child and call it something other than a gift or bequest. If we heavily subsidize bequests, then most of the same avoidance mechanisms would work in reverse. I would want to pay my parents' bills so that they leave me with a larger, now subsidized bequest. Any tax lawyer or law student who has encountered the challenge of distinguishing gratuitous transfers and exchanges in the income, estate, and gift tax contexts will view the possibility of implementing a bequest subsidy with considerable skepticism. Farhi and Werning consider optimal bequest taxation under what they describe as an ad hoc restriction that rules out negative marginal rates. They find that if bequests can't be subsidized for some reason, it's still optimal to impose a positive and progressive bequest tax with a very large exemption amount, which is more or less what we have in the United States today. Lawyers would likely say that Farhi and Werning's restriction is anything but ad hoc. Unless our legal technologies for distinguishing bequests from intergenerational exchanges become substantially more sophisticated, a bequest subsidy probably is something that we ought to rule out. For tax lawyers, the conclusions of the new dynamic public finance with respect to bequest taxation are of clear interest. In recent decades, enthusiasm for estate taxation within the legal academy has waned. Edward McCaffery's 1994 Yale Law Journal article, The Uneasy Case for Wealth Transfer Taxation, captured a widely held view that the estate tax was broken and not worth fixing. One normative payoff from the new dynamic public finance is to provide a robust set of welfarist justifications for the taxation of intergenerational wealth transfers. The implications extend beyond tax law. Take, for example, the rule against perpetuities, which has been the bane of first-year law students for generations. The common law rule requires that a future interest in property must vest no later than 21 years after the end of a measuring claim. Most US jurisdictions have replaced this with a somewhat simpler rule that an interest must vest or terminate within 90 years of its creation. Several states have abolished the rule entirely. The rule against perpetuities plays a facilitative role in an estate tax regime. It ensures that families can't move assets into dynasty trusts and thereby escape estate taxes into eternity. The case for retaining the rule against perpetuities is thus bound up in the debate about whether we should have an estate or inheritance tax. If we have such a tax, the argument for the rule gains strength. The new dynamic public finance, insofar as it clarifies the case for estate taxation, also sheds light on non-tax doctrines like the rule against perpetuities that are complementary to an estate tax regime. A final area of overlap between law and dynamic public finance concerns a category of issues falling under the heading of dynamic political economy. This is the George H.W. Bush problem. How do we know that the government is really going to adhere to the tax schedule that it promises? Consider again the benchmark two-period Atkinson-Stiglitz model, where individuals work in period one and then consume across period two. In period two, a benevolent government would want to confiscate all the wealth and redistribute it equally across the population. This wouldn't distort labor incentives because all the labor already occurred in period one. And it wouldn't distort savings incentives because there is no period three. Of course, if individuals in period one anticipated that the government would confiscate all their wealth, then their labor and savings incentives certainly would be distorted. So the government in period one would like to commit not to confiscate, but it's not obvious what commitment technology it can use. One key insight from the new dynamic public finance is that the time and consistency problem is not limited to capital. It applies to labor too. Imagine that the government announces tomorrow that everyone's tax liability going forward will be based on the 5-year average of their income from 2016 to 2020. Nothing we do in 2021 or thereafter will affect our tax liability. In that sense, the tax would be as if lump sum. Past income isn't a perfect proxy for skill, but it's a very good proxy. So the non-distortionary retrospective income tax seems like a potentially attractive idea. Yet if individuals anticipate that the government will do this in the future, then as in the capital confiscation case, the distortions in the run-up would be severe. The time inconsistency problems in capital and labor taxation have direct relevance to law. For example, a constitution might constrain confiscatory capital taxation by imposing limits on rates or levels. More than 40 US state constitutions actually have provisions of this sort. The federal constitution doesn't, but it arguably requires that a wealth tax be apportioned among states in a cumbersome manner that would seriously discourage adoption. The Fifth Amendment Due Process Clause also arguably rules out retrospective labor income taxation, though this is not entirely clear. A trio of due process cases from the late 1920s, Coolidge, Blodgett, and Untermeyer, would seem to suggest that Congress cannot impose a wholly new tax on transactions that occurred pre-enactment. Some have suggested that these cases are relics of a bygone Lochner era. A more charitable view is that their holdings mitigate the labor distortion cast by a potential retrospective taxes shadow. Of course, constitutions are no panacea for the problem of time inconsistency. They can be amended, and judicial interpretations of constitutional provisions can turn on a dime. A paper by Bissin and Rampini from 2006 suggests another way for governments to provide assurance against confiscation: anonymity. For example, by allowing citizens to open secret offshore bank accounts, a government might bolster its promise not to confiscate wealth. The credibility enhancing effects of anonymity need to be weighed against the welfare loss from not being able to tax capital. Which way the balance ultimately depends may vary from country to country, depending in part on the ability of the country's legal institutions to generate credible commitment through other mechanisms. A paper by Farhi et al. 2012 suggests another way that governments can bolster their promise not to confiscate capital, by ensuring that inequality doesn't become too extreme. In their model, a government can confiscate capital at some cost, either a fixed cost of legislating or a cost associated with reputational damage. The cost is worth bearing only if wealth inequality is sufficiently high. So by adopting a progressive capital tax, the government can ensure that wealth inequality never exceeds the threshold at which confiscation would become ex post optimal. An implication of their analysis is that once dynamic consistency considerations come into play, the equity efficiency trade-off in the static Mirrlees model might not be a trade-off at all. Greater equity reduces the present period labor and savings distortions arising from the shadow cast by the threat of future expropriation. So like other joinders of law and economics, law in the new dynamic public finance does not yield a single set of unambiguous policies prescriptions. But it does help us understand aspects of our existing law, and it causes us to question propositions that we previously took for granted. In this respect, law in the new dynamic public finance resembles its predecessors: law in public choice, law in corporate finance, empirical law in economics, game theory in the law, and behavioral law in economics. The comparison with behavioral law in economics is particularly generative. The new dynamic public finance is, in some respects, the polar opposite of behavioral economics. Whereas the new dynamic public finance imagines individuals choosing rationally among consumption income bundles, behavioral economics highlights all the irrational aspects of individual choice. Whereas the new dynamic public finance generally assumes foresight on the part of individuals, behavioral economics emphasizes myopia. The new dynamic public finance suggests that government should tax people to stop them from saving too much. Behavioral economics suggests that the government should nudge people to save more. But upon further reflection, perhaps the contrast is not so stark. For example, foresight is not a hardwired assumption of dynamic public finance. It's a parameter. If we thought that individuals fail to fully internalize the interests of their future selves, then dynamic models of capital taxation would come to look like dynamic models of bequest taxation. This would be consistent with the philosopher Derek Parfit's suggestion that perhaps the relationship between our younger and older selves is not so dissimilar to the relationship between ourselves and our children. One final way in which law in the new dynamic public finance hopefully comes to resemble behavioral law in economics is institutional. The University of Chicago played an outsized role in the emergence of behavioral law in economics. Indeed, one could say the same about every law in economics iteration since Ronald Coase arrived here in 1964. Chicago's comparative advantage is the union of a world-class economics faculty with a law school that holds a healthy disregard for disciplinary boundaries and a high tolerance for intellectual risk. What exists of the law and dynamic public finance literature is dominated today by individuals associated with Chicago in some way, especially on the economics side, where most of the major papers in the field have either a Chicago economics PhD or current Chicago faculty member as co-author. While the dynamic public finance emphasizes the importance of shocks, this is a feature that I hope remains constant. With that, I very much look forward to your questions.
Thank you very much, Professor Hemel. Thank you for that wonderful set of remarks. I encourage everyone to advance their questions and to raise your electronic hand. And then, Professor Hemel, I'm happy to call on people, but I think you're perfectly capable as well as calling on people. I think we've got a number of questions already in the queue.
Great. Professor Dharmapala?
Thank you very much for a very engaging lecture, very thought-provoking. So just one brief comment and just kind of somewhat broader question you compartmentalize labor and capital taxation, but actually age-dependent taxation has in some of these NDPF models the feature of being a kind of rough proxy for capital taxation or vice versa. So when age-dependent labor taxes are available, then capital taxation is less attractive than it would otherwise be. And it's more attractive when for whatever reason, labor income taxes cannot be conditioned on age. I believe that's what at least some of this literature finds. Matt Weinzel, for example, I think finds that age-dependent labor income taxes would capture a lot of the benefits of capital taxation because it's kind of partial subsidies for each other. And the broader question is, you said that what this literature does is to justify the status quo with respect to capital taxation. And I think that's right in a very broad sense, but there's a lot of detail that isn't necessarily that may not necessarily be the case for it. There are no legal entities, there are no corporations in these models. And so conditioning a tax on a particular legal entity status is not something that can necessarily address one way or another. Also, this basic intuition about savings changing your elasticity of labor supply is that's the central insight, but it's not immediately clear to me whether that has to be, whether that's supposed an accrual based or a realization based tax on capital, and just wondering if you could address those questions.
Great. So thanks for those comments. Professor Dharmapala's first point is about the interdependence of the age-dependent linear and capital rate schedules, and what we can do with capital taxation may affect what we want to do with age-dependent labor taxation and vice versa. There's one view that a capital tax is going to impose a higher effective tax rate on people earlier in their life when they've got more years to save, right? And a very low effective tax rate on people at the very end of their life. Because if you don't have a bequest motive and you're 65, you care less about a capital tax than if you're 30 and you've got lots and lots of years of paying the capital tax. So there are some models in which age-dependent taxation is ruled out, and then a capital tax or capital subsidy becomes optimal. I think there's no reason to rule out an age-dependent tax. We have age-dependent features of our current code. So I put more stock on models that allow for age-dependent linear or nonlinear income taxation rather than those that rule them out, right? The EITC, you've got to be 25 if you don't have kids to claim it. There are other provisions that kick in at 50 or kick in at 65 or kick in at 59 and a half. I very much agree with your point that this is not fully justificatory. In fact, if an enterprise were going to be fully justificatory, it's probably not worth it. There are many ways in which we might adjust capital tax schedules based on the insights of the labor income tax. Based on the insights of new dynamic public finance. One is we might want to think very differently about business assets and non-business assets. So the dentist who owns his own or owns her own practice, that's a form of capital taxation that's probably not going to deter future labor supply. In fact, there, capital is a complement to future labor. So one potential implication of the model is to draw a distinction between capital that you use in your business and capital that you simply have sitting in an IRA. There are some ways in which current US tax law gets that right, and actually gives us a lower effective rate on active investments. The loss limitations in the code do that. There are other instances in which it gets it wrong, where our IRA provisions are pushing you to invest not in business assets. Great. Professor Golden?
Hey, so that was great. I always think when you're describing something I already know, I always end up learning a lot of new stuff and realizing I didn't really understand it before, so thanks. In the spirit of your talk, the part of optimal tax theory that's probably been the most influential previously in other areas of law is like Kaplow and Chevelle, right? Applying Atkinson Stiglitz to the idea that all redistribution should happen through the tax code, as opposed to like tort law, say. And you sort of hinted at some of this, but do you see some of the arguments you made as potentially challenging that result? Something where like, well, I'll let you get it, or do you sort of think of them as sort of just like analogous, like intellectual endeavors, but like sort of substantively just different conclusions?
Yeah, so there's an important paper by Louis Kaplow and Steve Chevelle from 1994 that applies Atkinson-Stiglitz insights to whether we should have redistribution via legal rules. And the takeaway is that the tax system can do it better. I don't think that the new dynamic public finance will, I mean, this is a bunch of people at different institutions who are working on different problems. So there won't be one hive mind that comes to a single conclusion. I don't think it will yield a single conclusion, but it will suggest that the extent to which we want to use law in aid of redistribution depends critically on what we can do through the tax schedule, right? So if we can have an age-dependent tax schedule and consumption smoothing, then maybe we don't want to think about consumption smoothing when we are setting consumer financial regulations. If for some reason we rule out an age-dependent tax schedule because we just don't have the legal technologies to stop people from engaging in income shifting, then that will inform our other mechanisms. But I think that's quite in the spirit of Kaplow and Chevelle. Right? They don't think that you should entirely ignore the income tax when setting legal rules. Most of the simple fact that a legal rule is redistributive is not sufficient justification for the legal rule. I think that will carry forward into the new dynamic public finance informed analysis as well. Anna?
Oh, yes, hello. First of all, thank you for giving me the opportunity of asking you a question. We've seen the rise of private space enterprises such as SpaceX and Blue Origin. And in the future, perhaps in the next 20 years, we will see these companies and many others endeavoring to space conquest and asteroid mining. However, most governments are unprepared for this future, and space law is not developed enough to keep up with the technology. So in a nutshell, my question is, how do you tax space? And who oversees the buying and selling of space, especially asteroids worth billions of dollars? And how do you tax the newly minted trillionaires created by this industry, as the power and wealth of individuals starts rivaling or surpassing the revenues of countries themselves? Thank you.
I won't be able to answer questions about the taxation of space, though they're interesting. I'll pick up one point from that, which is that the new dynamic public finance highlights the extent to which the optimal tax schedule is going to depend upon a country's legal institutions. So in that sense, the prescriptions might be different from for a developing country and for a developed country. But it may be that for a developing country, the anonymity route toward credibility is more attractive than it would be in the United States. Professor Fennell?
Yeah, thank you. So I was curious how much traction we might be able to get by thinking about the timing of tax collection as a separate moving part from the way that we do the imposition of different tax schedules that apply to different parts of the life cycle. Because there's several reasons why we might want to move around taxation, and some of them have to do with when we want people to have money. Liquidity issues, smoothing issues, There's even psychological effects that might impact people wanting to like engineer for themselves, improving sequences over time or other things as far as the money that they have. And that might be a different question than kind of some of these elasticity questions about when we want, how we want to tax income that's earned in different points in the life cycle. So I wondered if you could speak to that a bit more.
So the answer to that question will depend critically on the efficiency of credit markets. So we need to we need to talk to our bankruptcy law scholars about bankruptcy law before we move to a system that, say, backloads all tax payments or front loads tax payments. There's some papers in dynamic taxation that suggest that anything you want to do with, say, history-dependent taxation, taxation that it depends how much your tax on this year's income depends in some way on how much you earned last year, that we can do it all at the end. We can do it all in the Social Security system. And maybe we can have something that kind of looks like our current labor income tax, and then a super sophisticated Social Security system that's actually based on your individual work history. And we kind of have that on the Social Security side today. That's going to raise two important questions. To what extent should we think of people as able to shift income across their life cycle, which if we've got perfect credit markets, they can, but we don't have perfect credit markets. And then this gets to the point at the end about the Derek Parfit perspective. If we think of different stages of individuals' lives as different, the same way that we think of different generations of the same family, where their interests are interlinked but not identical, then the idea of totaling it all up at the end makes less sense, because that person who you are at the end is less the same person who you are at the beginning. And then that gets into, I think, deep questions about the nature of the self that we actually do have to answer in order to fully specify an optimal tax schedule, but I'm probably not going to be able to do in a remaining minute.
Thank you, Professor Hemel. I want to, unfortunately, we're just about out of time, but we have more questions. I'm sorry we didn't reach everyone with the questions, but I really want to thank Professor Daniel Hemel for a sensational and incredibly stimulating and intellectually ambitious Coase lecture. Please join me, everybody, in thanking Professor Hemel. And thank you, everyone, for joining us for our 2021 Coase lecture. Thank you very much. Have a great afternoon.